see here. Terry Strickland versus Getz. This party should come up, please. All right. All right, I have it on the calendar for motion for a modification of custody, motion to dissolve the parental rights of the plaintiff, and motion for summary judgment. Any other motions, preliminary motions prior to calling the case?
No, Your Honor.
Getz, anything prior to calling the case? Motion.
I have a motion for removal of parental rights.
Your parental rights, or? All right. All right. So how does motion break down? Y'all's motion for modification of custody, or?
Your Honor, all the motions were filed by Mr. Getz. An order was entered, actually a temporary order, back in October 14, 2002. And our position is that it's a violation of law based on neither party petitioning the court for a significant period of time that becomes a final order.
Oh, the earlier order, how long was that in effect?
It's been in effect now for almost 7 years. Now, Mr. Getz has filed a motion to terminate parental rights. And I don't think the court needs to spend very much time on that because there's really no legal merit to it. There's a procedure or process to terminate an individual's parental rights, and that's set forth in Chapter 7B, and there's just no legal authority at all to address that here today. I don't know if Mr. Getz has any legal authority at all to support that position, but I would say...
Are you saying in fact, or are you saying...
I'm saying it's a legal matter. I mean, in order to terminate parental rights, you have to file a petition to terminate legal rights. It's got to be verified. It's filed under Chapter 7B in juvenile court. It's not filed in a Chapter 50 proceeding. Aside from the legal aspect of it, it is absolutely meritless with regard to facts. But we could spend a significant amount of time dealing with facts, but as a threshold matter, from a legal standpoint, it's not maintained.
Oh, a motion to terminate under Chapter 50?
He filed it in this proceeding as a motion in this court.
Mr. Getz, is that correct?
Well, sir, there's a number of things we spoke about I'd like to reply.
Well, I'd like to first of all know if you filed this in juvenile court, or you filed this as part of Chapter 50, which would be in custody.
Being I'm an attorney, I basically filed in response to that hearing.
Well, you're going to be treated as if you are an attorney representing yourself. You understand that, right? Yes, sir.
The fact that it's taken 7 years is not in my control. I moved here with my daughter from Texas 7 years ago. I thought we were going to be married in a family. After I got here, they turned against me and put me out on the street. And I was put
basically almost 7 years now, been fighting to get off the street. I finally got back on my feet. During that time, I've been maintaining a relationship with my daughter. I know I'm not an attorney and there might be mistakes in my case, but what has to be done is what's best for my daughter. And I have solid evidence over a long period of time that her mother has not acted in a condition that is appropriate of a good mother. And I hate to have to do this, but I have to be able to get my daughter her safety and her health in check. As her father, I have both the obligation and responsibility, losing faith in her mother, to have to stand up and do this. I ask the court to recognize her actions and how it has hurt my daughter, and I ask the court to help make sure my daughter is okay.
Well, certainly that's a paramount interest of the court, but under some recent case law, I mean, it'd be very clear that a temporary order entered in October of 2002 would be considered under some recent case law to be a permanent order to require you to show up.
Sir, I had no control. I was living on the street. It was impossible for me to be able to do anything. And now I must do so. Knowing the facts that I do about her mother and the way this has all gone down, my daughter is not safe with her and her family without me there. I'm doing the best I can. I actually overlooked some proceedings in the effort to make sure my daughter is okay.
Well, I'll certainly do that, but I can't overlook procedural problems you have in filing it. First of all, your motion to terminate parental rights.
My effort is only to establish control of my daughter, not take her away from her mother. At this point, for 7 years, I've been kept from her, and it's hurt her. And I've waited patiently for some changes on her mother's behalf and her family. They seem incapable of doing so. I have to establish control to make sure she's okay. And at that point, I'd be happy to make sure that she has her mother and her grandfather around. I'm not trying to keep anybody apart. So as long as she's in control, this is the way it's going to go, I'm sure.
All right, well, your motion to terminate parental rights is denied. Is that what your motion for summary judgment is?
No, Your Honor. Mr. Getz, on an issue of custody, has filed an unverified, unsupported motion for summary judgment. As Your Honor is aware, a custody determination is very factually specific. It's not the kind of case that is even susceptible of being decided by summary judgment. Even if it were, Mr. Getz has not supported his application with anything other than a signed motion, no affidavits, no nothing. So we would ask that that motion be denied as well.
Mr. Getz, you're saying when you file a motion for summary judgment that there is no material issue in the case. There's nothing for the parties to fight about.
So it was my intent to try to solve this problem before I have to prove my case. I do not want to be here to talk bad about my child's mother. I'm trying to make sure she's okay. There were two big issues that were a problem with the current ex parte custody order.
Well, let's don't get into that part. The issue here in a summary judgment motion is whether or not there's an issue of material fact between the parties. When the parties agree on whatever is at issue, then a motion for summary judgment is appropriate. In other words, you owe me $10,000. Yes, I owe you $10,000. I just can't pay it. That would be an appropriate for motion. But here you're saying something about them. They're not agreeing with it.
No, sir. My summary judgment is based on the fact we were not residents here for 6 months. The court order is invalid, and I believe that's a statement of fact. There's nothing to argue about. It's right in their legal paperwork. We were here 2 months before I put out the street.
Your Honor, the parties have lived with this order for almost 7 years. This man has been exercising visitation for almost 7 years. And now here we are on his motion to modify custody. He wants to argue, I guess, that there's no jurisdiction here, which is without merit at all.
The court requires 6 months residency before you have authority. We were not here 6 months. The order is invalid.
And, Your Honor, if you follow that logic to its end, then what will happen is we would simply vacate any orders in the case presently, and then we start back from square one. And that, I would submit, is just not what the law requires.
I agree that a custody arrangement at this point would be best for my daughter, but I cannot deny the fact. This order is invalid.
All right, motion for summary judgment denied. All right, so that leaves us with a motion for modification of custody. Is that your motion?
Yes, sir.
All right.
Ex parte custody order.
Well, at this point, it's a permanent custody order under the law of this state. All right?
It's the only order in place, so that's what you're saying, the ex parte custody order is permanent, and that's what I'm asking to modify.
That's the order of October 2002.
There was an ex parte custody order that became a permanent order. You actually were temporary order back in October of 2002. Your Honor presided over the case then and entered the order. So we don't have an ex parte order any longer. We have a temporary order, which, again, arguably from a legal standpoint, is permanent.
You may put on evidence to change the order, but at this point, it's a permanent order under the law of this state. After 7 years, or just about 7 years, it becomes a permanent order. Okay?
And I asked the court to modify it, take into consideration my evidence for her mother's action, and allow me to have my daughter back.
Right. It's at this point you have to put on evidence. You ready to do that?
Yes.
All right. We'll call your first witness.
Yes, sir. Just like my opening statements, and then go from there.
You got 2 minutes.
Yes.
Your Honor, before we get into his opening statement, on the calendar it's indicated 2 hours and a lot of the case. Is that going to be?
That's correct.
Okay. So each side gets an hour, including cross-examination, goes against each party's respective time.
That's correct. Okay. All right, you got 2 minutes for an opening statement. You may proceed.
This day has been a long day coming for me. I wish I were not here. I wish we did not have to go through this. I have tried every way that I know to make sure that my daughter is okay and to get along with her mother. My name is Michael Lee Guest Sr. I am the father of Stephanie Ann Guest. Her mother, Sherry Strickland, and her family invited us here after our child was born. In my mind, as I understood it, to be a family. We were engaged. We came here to be married. Shortly after we arrived here, they turned on me. I was jumped, beaten, and put out on the street, forced to the street. The last time I saw you, you gave me 48 hours to get out of my house. I ended up in a homeless shelter and living on the street. For 7 years, I have struggled to survive. I have maintained my contact with my daughter 3 times a week. Sometimes riding a bicycle 30 miles round trip in all kinds of weather just to spend an hour with you. This situation is absolutely wrong. I've tried everything to get along with no chance of any differences. I come here today not to speak bad about Miss Strickland. She's the mother of my child. I never wanted to be here. But as her father, losing confidence in her ability as a good mother, I have both the obligation and the right to step up here and ask the court to give me my little girl back. I was there when she was born. I cut her vocal cord. I saw her and she saw me. I was the first thing she saw in this world. I took care of her every day until we came here and had her taken from my hands and put out on the street. I am the primary care provider by every definition, except that she made more money than me. It is in the best interest of my daughter for me to maintain control of her life and make sure that she has family, not be destroyed as Ms. Strickland has done. I have brought evidence, and I provided to the court and the attorney on the things that I'm talking about, and it is pretty. I do not want to have to show evidence of this, but I will. I ask the court to modify the custody order and give me my daughter back. As her father, I have obligations that I must do, and with this current situation, if it doesn't change, my daughter's health and future is at stake. That's my opening statement.
All right, thank you, Mr. Gibbs. All right, any opening statement?
Yes, Your Honor. Your Honor, Stephanie will be 10 years old in December. This order's been in effect for 7 years. During that time period, Ms. Strickland has been the primary caregiver. This little girl attended Montessori school full-time. This little girl is now attending Aiden Elementary School. The evidence has been made that she's doing very well. She's got extended family here in Pitt County. She's got cousins. She's got aunts, uncles. She's very well-adjusted. She's happy. Since 2002, Ms. Strickland has provided almost all the financial support. The evidence is going to be that up until a child support claim was commenced in, I think, in September of last year, Mr. Getz had paid a grand total of $520 in child support over that entire 6+ year time period. Mr. Getz is coming into this courtroom saying that this is my child, and he goes so far as to file a motion to terminate parental rights. Ms. Strickland's done nothing but right by this child. Ms. Strickland's father, who's in his 70s, 3 times every single week over the last 7 years has accommodated Mr. Getz with this custody order. Now, standing here today, I think Ms. Strickland, of course, will tell you that she feels like a modification would be appropriate. The child is almost 10 years old, and she'll tell you what she thinks is appropriate. But in terms of modifying the custodial arrangement, in terms of who's primary custodian, the evidence is going to be conclusively compelling that no such modification is warranted. And we ask that the court deny Mr. Getz's motion to modify in the sense that he's trying to change primary custodians. We're not opposed to a modification being made in some respects that will accommodate and take into consideration the child's age and things that have occurred in the last 7 years.
All right, well, both parties' ground rules are that you've got an hour apiece to put on your evidence. That includes questions that you ask the other party, okay? So when you cross-examine the other party, that counts in your hour, okay? We have a number of cases after this, and we keep everybody in line, and we'll proceed as quick as we can. All right? Mr. Getz, since you're the petitioner, you may proceed to offer any evidence you wish to offer. You have to do that under oath. You have to come up and do that under oath, okay? If you want to bring any papers with you, you certainly do that too, okay? If you'll put your left hand on the Bible and raise your right.
Yes.
All right. You can have a seat right there. All right. For the record, if you'll state your name for the court, please.
I'm Michael E. Getz Sr.
All right. And you may proceed.
As I said in my opening statement,
First of all, where do you live?
6202 Turnage, Farmville, North Carolina.
How long have you lived there?
About 5.5 years.
All right. You may proceed.
Sorry?
You may proceed.
As I said in my opening statement, the reason I've asked this today is not out of anger to hurt anyone, but it's because I've lost confidence in my child's mother to make wise decisions in regards to my daughter. Over the last 7-8 years, I've collected evidence on the things that have gone on, and it's for those reasons that I had to come here today. Some of the things that have bothered me since I met Miss Strickland, back after she was first pregnant,
Yes. We're going beyond the order. The order was entered in October of 2002. If we're going to go back to the dawn of time, we're going to be here a lot longer than 2 hours.
I have 2 statements, short and quick.
Mr. Getz, you can't be talking about what happened before you all met.
I'm talking about, in relation to my daughter, the things that have happened.
Listen,
Sorry?
listen to me. We have rules here. All
Right.
From the date of the last order, okay, which was October 2002, anything prior to that was presumably covered by that order. So anything you want to say to change the custody or to modify another order has to go from the date of that order up to now. Okay, anything before that presumably was covered in that order, and you're not allowed to go back over that.
My actions since that time are based on these 2 statements I have to make.
And you can't talk about anything that happened before October of 2002.
Yes, sir, I understand that. I'm saying what I'm doing right now is mine.
Don't do that. Now remember, anything you testify to, this is another, just get you to, so you won't get frustrated with objections, because they're going to come.
Right.
It has to be things, you can't say anything somebody else told you.
No,
It has to be something you saw, Okay, you got that?
Yes, sir.
Okay, all right, you may proceed.
Difficult to answer under these conditions and this important
Well, these are
information.
conditions which every courtroom in the country is under, so.
I'm here today because Terry Strickland tried to kill our child and abandon it.
Objection.
That is important.
This happened before 2002,
When she was
October.
pregnant and after our child was born, when we were coming here, that's why we came here. Because I couldn't lose my daughter and I was afraid she was going to kill her.
This is before 2002 order?
When we came here at that time, I don't have the exact date, but when we came here, it was about that. That's what I'm trying to explain. I'm not here to try to make problems. I was worried absolutely about the safety of my daughter. And her family has a history of sexual abuse.
Objection.
That is since. That is not before.
My objection was based on prior to the October 02 order. He said they moved here together. They have not reconciled since October of 02, so that by definition would have to precede that.
Mr. Gibbs, you have to talk about what happened after 2002.
Since we arrived here, shortly after arriving here, being invited here, I came.
Objection. Again, the order was entered in October of 2002. He's talking about shortly after they arrived, which would have preceded that order.
In 2002, 2002, June 2002. Shortly after that, when all this paperwork is here, referring to that time, shortly after that, she comes home one day, says she doesn't love me. She's taking her child and put me out on the street.
Objection.
This is during this time period, 2002.
No rule, I'll set it for background.
I'm just trying to explain why I'm feeling like I am and why I feel like I have to step forward and do something.
That was 7 years ago.
And during that time, after she came home and told me that she didn't love me and that I had to get out on the street and she was taking our child, that while I lived on the street, she made it almost impossible to be able to allow me to see my daughter for the last 7 years. I've had to go through quite a bit, including many occasions, riding a bicycle 3 hours round trip to spend an hour with my daughter. My daughter has not, on the average, been allowed to come to my house except for a few occasions, exceptions like maybe Christmas once or twice. My daughter is not allowed to be able to come to my shop, my PC shop, where up until the time we got here, she used to work with me as a baby. I believe that during this time, the actions of Ms. Strickland.
You say you have a business?
Yes, sir.
What type of business is that?
Mike's PC shop in Farmville, at the computer shop.
What?
PC.
Oh, PC.
Yes, sir.
Computer?
Yes, sir. During the 7 years, I believe that her actions have not been conducive with a good mother. She has destroyed her family. She has made it nearly impossible for her daughter to see her dad. She has kept me from being able to make any decent decisions in my daughter's life. I have not had any opportunity to have say in her life. For instance, she is on medication right now for ADD. I'm not a fan of that, being a substitute school teacher also. I see what kids go through that are on those medications. In the discovery process leading up to today, there were a number of just flat-out wrong things. And I think that they're important to get the facts straight. The fact is, if I may, or to go through these discovery, sir?
You can certainly go through some of what's objected to, and then we'll talk about it.
Right. In the interrogatories, I made an attempt to try to get as much as possible as I could agreed upon before we got here. There are things that, in my mind, shows a consistent pattern of deception. They're not being honest. They're not being straight. It is my opinion.
Objection.
And I have facts for that. There are a number of things, like I wasn't there when my child was born. Didn't cut her umbilical cord. I got videotape evidence of that. That I wasn't jumped by Mr. Strickland and his son. I got videotape evidence of that. These are plainly wrong. And I want to make the fact, these people are not being honest. Ever since I got here, they have twisted and turned and done everything possible to try to keep me away from my daughter. No decent person would keep a good man from being a child's father. Your position is indefensible.
All right, talk to me, not to them.
These are just two of the things in the discovery that are plainly wrong, and I'm willing to submit evidence unless they concede.
About what?
That I wasn't jumped, I wasn't beaten and put out on the street, that I wasn't there and cut the umbilical cord and the first thing my daughter saw, that I wasn't the primary care provider of my daughter all the way up to the moment that we arrived here and they took her from me and put me on the street.
Yes, please listen to me. I'm trying to listen to you, but you're getting off on things that happened when the child was born. We're talking about a modification of a custody order, wanting to change whatever agreement is between the two of you right now. That's what you need to focus on.
Sir, I completely understand your point, but the fact is, at this moment, Miss Strickland's actions are not conducive with a good mother. At this moment, not
Talk
the
about
past.
this moment. You're
Yes, sir.
exactly right. Talk
Yes, sir.
about now.
Yes, sir. I am not allowed to see my daughter except for 3 one-hour visits a week. I am not allowed to make
How
any
many
decisions.
hour visits a week?
According to your court action, I was put on the street and given 3 one-hour visitations a week. I had originally asked for Saturday, Sunday, and Wednesday, but you gave me Saturday, Sunday, and Thursday. During this time, up to now, I have not been allowed to be a part of my daughter, her life. I haven't been able to be a father to my daughter, and those are through Miss Strickland's actions. I have tried everything to get along. It's not happening. I have to step forward and say something, and these other things are part of background. It's important that people realize I'm not here just mad. I'm very concerned about my daughter, and I have major problems with what's been going on ever since my daughter was born. So I would like to know, are we going to be able to agree on some of the facts, or should I present evidence to the fact of repeated bad decisions by Ms. Strickland up to this moment about my daughter?
Apparently, you are past the stage of agreement, so yes, you're going to have to present evidence.
All right, well, I'd like to just confirm a few things here. According to my interrogatories that I got back from Ms. Strickland, her attorney, I have videotape on my computer that I would like to play.
Well, what?
Being jumped by Mr. Strickland and his son, about being with my daughter at birth and being the first thing she saw and cutting her vote, the things that they are plainly lying about.
Objection to the characterization.
The facts are not accurate, and you know that.
Mr. Gibbs, please listen to me. You remember it's a 2002 order, right?
Sir?
We have a 2002 order.
Right.
That was entered after the child was born.
Yes, sir.
Correct?
Yes, sir.
So the umbilical cord tape would be totally irrelevant, right?
It established
Do you
a fact.
understand that?
I understand your point, but it established the fact they're not being honest.
Do you understand why you're here?
Yes, sir. I'm trying to make sure my daughter's okay.
You're asking for a change in the custodial situation, correct?
Yes, sir.
What relevance does whether you cut the umbilical cord of this child have to do as to whether or not there should be a change of custody?
I was the primary care provider to my daughter. I was the one with her every day, taking care of her all the time from the moment she was born. It should be allowed to continue, and it should cause merit whenever you ask who should be taking care of the child. And that there is a repeated pattern of lies in their responses.
Why don't you tell me why you think she's a bad mother and not start before 2002 and start...
In 2002, yes, sir. In 2002, I was jumped and put out in the street and had my daughter taken from me. I lived on the street for 7 years.
Tell me, after 2002, what has changed to want me to change this order that was put in effect in 2002? That's what you should be doing.
Yes, sir. In the last 7 years, my ex has kept my daughter, I believe, from me, except for the court-ordered visitation. She has repeatedly made decisions that are not conducive to a good mother. My daughter...
Tell me how.
Well, taking her father from her is probably a big deal. In fact, it's the biggest deal to me. Unbelievable. After inviting me here and then putting me on the street to die. And then keeping my daughter from me. It's not even a good person, much less a good mother. How can I stand here and not say nothing? And that is the crux of my argument, that it is a repeated pattern of bad decisions that destroyed my family, that goes on today, that will not change unless I step forward and do something about it. And that's why I'm here.
Do you think the custody ought to change to you, or it should be modified to give you more visitation, or what?
I need to be in charge of my daughter. I am Mr. Getz. My daughter is Stephanie Getz. We are a family. She has two brothers, Michael Getz and Justin Getz. We are a family. Miss Strickland was supposed to be in our family and chose not to. I believe that that decision was probably a mistake. To keep us apart like this, destroy us after inviting me here.
Where's the other children?
They're back west with their mother. I'm divorced. I'm fighting for custody of them, too.
Okay, so you got two children that are elsewhere.
Yes, sir. My oldest son is 27. And he's,
So you got two children elsewhere, and then this child here.
yes, sir. And so I'm asking for legal custody of my daughter. The physical arrangements of her living where she is now, I totally understand. I don't want to rip her out of that. I mean, even though I don't feel comfortable with her being there, in my opinion, having a history of sexual abuse, and me not being able to protect her or being around her is a mistake. But I'm willing to negotiate where she actually lives. But what I need and what my daughter needs is for me to be in control of her life, not shared custody, because it's constant conflict and it'll tear my daughter apart. I'd rather let go. So I come here today to ask for legal custody of my daughter, and I'm willing to negotiate physical custody of my daughter, although I would like to ask the court's clarification that if I am given legal custody, I may ask if I can take my daughter and the Getz family and go back to Texas. But right now, I'm only asking for legal custody to ensure the safety and health of my daughter after a long, prolonged, documented pattern of bad decisions and conflict between me and her mother.
Now, you keep talking about this documented long history between the two of you. Tell me something about that.
Well, the videotape of me being jumped and put out on the street when I got here, the 7 years of having to go through unbelievable pain and suffering riding a bicycle back and forth from Farmville to Greenville because they refused to even bring her to my shop or Farmville at all, knowing that I had to ride 3.5, 4 hours round trip on a bicycle to spend an hour with my daughter at Burger King or McDonald's. Since that time, I haven't contacted Ms. Strickland in any way since we've been here. To the best of my ability, I stay out of her way. I don't bother their family in any way. So our agreements between us, our actions between us have been very limited. But taking away her father, putting me through this, keeping me from her, with the history of problems and the things they have, and me not being able to be there and know where my daughter is, or I can't even call my daughter. She can't even call me, although they keep saying that she can. That's not true.
Are you saying that they haven't followed the terms of the October order?
The October order is what has limited us to this point. And they have violated by not showing up, not providing my daughter on numerous occasions according to the order. But to the larger degree, I'm not saying they have violated that court order. I'm saying that we shouldn't have had it. We shouldn't have been to this point. Ms. Strickland never should have forced this issue and never should have asked the court for that order. That is not a good mother, as much as it pains me.
All right, anything else?
I brought with me today an individual that I've known since I was on the street first here when I saw you last. And I was going to ask him to verify or at least give another opinion of the things that have gone on. Not being an attorney, I'm not really sure of the procedure in this case, but I don't want to take up the court's time. Everything I'm saying is absolutely truthful. I'm willing to back it up, but I do not want to have to. I don't want to have to talk bad about the mother of my child. But this is unholy.
Well, what is it that you want me to hear that says the order should be changed or expanded, or in this case, you're asking that it should be just turned over on the side and the custody go to you? What is the substantial change in circumstances?
Oh,
that has taken place between 2002 and today that require the order to be overturned?
Since that-
Essentially overturned.
yes, sir.
Yes.
Since that time, I've been able to get back on my feet. I'm a substitute school teacher. I'm a coach at the high school. I have a business. I have a home. Although business is slow right now, it stresses me a little bit with the economy. And I do want a family to help take care of my daughter, not just me or Miss Strickland. But the fact is, I am capable and willing and able to take care of my daughter. And in light of all these concerns, I believe that it's necessary for the health and safety of Stephanie.
Where are you a substitute teacher?
Pitt County Schools, mostly in Farmville High School, and I coach there.
What do you coach?
Football,
JV, varsity, or?
both, just about everything, and put them on the internet, which is kind of historic. And I've got letters from other people in the community, from coaches to teachers to business owners to customers of mine to neighbors that know me, that know I'm a good man, that I'm doing everything I can to be in my daughter's life, that I should be allowed to have my daughter. And I'm willing, I got those, I'll present those. Overall, I am capable and willing to take care of my daughter now. And I do want Miss Strickland and her family to be a part of that.
Tell me about where you live.
I have a small 2-bedroom house in Farmville, 6202 Turnage. I've had a room set up for my daughter for 6 years. And my shop is right there in town, like a half mile from there. As a substitute school teacher, my daughter can be in school with me. I can keep an eye on her and know where she's at all times, which stresses me since I've been here. As her father, I should know where she's at, who she's with at all times. She should be able to call me or come to me at any time she needs. That would allow this.
Well, how often do you communicate with her by phone?
My daughter, I am not allowed to call my daughter or anyone except for 1 hour before our visitation. I call Mr. Strickland to agree to meet in public somewhere for an hour. So I don't ever get to communicate with my daughter, although they keep saying that I can. I don't know. It ain't happened. I bought my daughter a phone. Somehow that's disappeared. So I've had almost no contact outside the 3 1-hour visitations a week with my daughter. I have newspaper articles that were written about me in Farmville. I have, again, letters of support from people in the community. You know, I'm a good man, and I can do this. I'm the father to Stephanie. I need to be able to do what I need to do as her father. This custody order must be modified to allow me sole legal custody of my daughter. And then I would be happy to negotiate the physical custody, and I'm not interested in trying to remove her family or keep her from her mother or grandparents. I'm trying to keep my family together. And so this time, I've been cut out of the family. And I don't believe that it will change unless I'm the one in control of my daughter's life.
All right, anything else you want to say on direct? You certainly have a chance to offer your witness in that, but anything else?
I would like to call David Strickland as a witness.
I'll certainly let you do that, but you cross-examination, you have to listen to his questions
Okay.
first, okay? All right, Mr. Booth.
Good morning, Mr. Getz.
Good morning.
Mr. Getz, I'm a little confused. You said that you were homeless for 7 years, and then you said that you've been living at your present address for 5.5. Which is it?
Both. I was homeless 7 years ago, and I had
Okay.
fought to get back off the street, and I finally got a place to live. It did not allow me to be able to come back and fight for my daughter because I didn't have enough money. I was barely surviving. It wasn't until this last year that my business did well enough to where I felt like I could fight for my daughter and take care of her.
Okay, so you've been living in this house for 5.5 years.
Yes, sir.
So how long have you had a car?
I have it. The first 2 or 3 years when I was living on the street, had a place to live, didn't really have one. When I came here, my truck was broke down. I've had It's a hard answer because I've had broken down vehicles back and forth over the last 7 years, and I've had to ride a bike most of the time.
Okay, so your testimony is more than half the time over the last 7 years, you've been limited to riding a bicycle for transportation. Is that your
I
testimony?
would say over the first 5 years, in the last 2 years or so, I have a vehicle and it's not a problem.
Okay. And until a child support complaint was filed by the 4D people, you weren't providing any financial support for the daughter you professed to love so much.
No, that's
Isn't
not
that
true.
correct?
That is not true.
Well, you paid a grand total of $520 until sometime in 2008 when that child support petition was
And I
filed.
bet you...
If you'd answer my question.
Yes, sir.
Okay.
I did. But that was about 80% of my total income. Living on the street, barely surviving. I gave everything I could possibly give.
Well, Mr. Getz, you just said that you have lived in your present home for 5.5 years. How much is the rent?
$250
Okay, $250.
plus utilities.
So 6 years, $520 total. That's about $100 a year. Divided by 12 months per year is what? $8 a month.
Basically, as a substitute school teacher, making $57 a day, and half of that going back to Texas for child support for my son back there, that left me with barely enough to live.
Okay.
And I still gave to my daughter. And more importantly, I met her 3 times a week, every opportunity I could to be in her life.
And in fact, the son you talked about a little while ago, you haven't seen him in over 10 years, have you?
I am fighting for custody.
If you'd answer my question, you hadn't seen him in over 10 years, have you?
I talk to him on the phone regularly.
In fact, you owe thousands of dollars to his mother in child support, don't you?
I found out about it when I got here and started teaching. I had no idea until I got here that there was even an order for child support.
Okay. And the other child that you talked about custody, he's 27 years old. There wouldn't be any custody issue there, would there?
Sir, he is in prison, and I'm trying to get them to release him to me.
Okay. Now, Mr. Getz, Mr. Strickland, Sherry's father, pursuant to that October 2002 order, has been the party who was facilitating your visitation with your daughter. Isn't that correct?
Except for the times that he didn't show up.
Isn't that correct?
Most of the time, yes.
Okay. And how many contempt motions did you file with this court alleging that Mr. Strickland, or I guess Sherry Strickland, was not complying with the order? How many?
I was unable. I had 0. But I had
0.
recorded conversations when they did
Okay.
not show
Sir,
up.
I didn't ask that. Okay. It's a fair statement, a true statement, that the overwhelming majority, in fact, you can count on one hand in 7 years the number of times that you didn't get visitation with your daughter.
Yes.
Okay. 3 times a week times 52 weeks a year, that's 156 visitations
But I wrote a
times 7 years. That's almost 1,000 visitations, and on one hand are the number that you didn't get to exercise.
It's still a violation of the order.
Okay. And in fact, when you opened your PC shop, Mr. Strickland brought Stephanie over to be present, didn't he?
For the opening.
Right, and that was your request,
Yes,
wasn't it?
absolutely right.
And he accommodated you on that, didn't he?
Right.
Sir?
Yes, sir.
Okay. And another time, he brought Stephanie by because you wanted Stephanie to see where you were living. Isn't that right?
It was at Christmas, I think.
Mr. Strickland brought the child by and allowed her to go inside your home to see where you lived. Isn't that correct?
Yes.
Okay, and that wasn't required by the order, was it?
It was a violation of the order.
Sir, it wasn't required by the order that he do that, right?
It was a violation of the order.
Okay, so Mr. Strickland violated the order by accommodating your request that Stephanie be allowed to go by your house and see where you live. Is that what you're saying?
They violated the order at their discretion. Whenever it wasn't in their benefit, they did not.
Okay, sir, they violated the order in your favor, didn't they?
On occasion, other times than theirs, most of the time theirs.
Okay, so you take issue with the fact that at your request, the Stricklands went outside the order to give you more than what the order required.
I take issue with the fact that when it's in their benefit, they violated it, and when it was mine or my daughter's benefit, they refused it.
You've been made aware of school functions and church activities and other special occasions, and you've actually been in attendance for some of those, haven't you?
a small percentage of my daughter's life, or maybe 1% of her life, I've been allowed to be a part of.
Well, Mr. Guest, tell me how many times you've been out to your daughter's school to talk with her teachers about how she's doing.
As often as I'm allowed.
Okay, and that's zero. Would that be fair to say?
Right.
Is there an order that prohibits you from being able to go out and talk with the teachers?
Yes, the current custody order
Okay.
that I cannot.
It
I cannot
prohibits.
be anywhere near my daughter, or I guess technically that's not right. I have a custody order where I am, according to Judge Blake, forced to be able to meet with my daughter in a public location for 1 hour, 3 times a week. And I've been doing that without fail, except for the times when they miss.
That's
And
good.
outside that, I'm not allowed, I'm not supposed to be able to contact them, so I try to stay away.
Mr. Getz, you're referring to the domestic violence protective order that was issued initially, which was in effect for a year and then renewed for an additional year. Isn't that correct? Yes or no?
No.
Okay, so-
That was thrown out.
Okay. The domestic violence protective order that Judge Blick entered, you're saying was thrown out of court.
The circumstances that brought that upon was thrown out. I did nothing wrong.
Okay. Are you disagreeing with the fact that a DDPO was entered against you after a full opportunity to be heard by Judge Blick? Is that what you're saying?
It was entered in, and based on the evidence, I understand why Judge Blake did so, but I did absolutely nothing wrong, and before it went to trial, it was thrown out and it was baseless, and since that time, she has even renewed it another year after that, and I haven't even talked to her.
Mr. Getz, how do you renew an order that was thrown out?
I don't know, sir, I was at my dead mother's funeral when you guys went to trial behind my back and did it. In Texas.
Sir, that wasn't my question. My question was, how does an order that's thrown out get renewed?
The charges that it was based on were thrown out, but it went on for 2 years based on y'all behind my back when my mother was dead.
Mr. Getz, I want you to show me in the existing custody order where it says you are prohibited from making contact with your daughter's school. Can you show me where it is?
Sir, why don't you answer me? What is the current
Sir,
arrangement?
Mr. Getz, you can't ask any questions. You're going in.
I'm trying to clarify.
You can certainly clarify anything you wish to that he doesn't ask you about on redirect.
Could you please clarify?
Can you show me in the custody order that was entered on October 14, 2002, where it says you don't have the ability or the authority to go by and talk with your daughter's teachers?
It's not in there.
Okay. And
That is the question.
sir, notwithstanding the fact that you had the authority and the ability to do that, you didn't do so, did you?
That's not true.
Okay, well, tell us when you went out there, Mr. Getz.
Sorry?
Tell us when you've been out to your daughter's school to talk with her teachers.
According to
No, answer my question. Tell me
I have, during the 7 years, done everything I could do, and I was not allowed to be able to do that. So, except for, I think, 1 or 2 occasions, where they made an exception, which I guess is a violation of Judge Blick's order, I was allowed to do that.
So my question again is, tell me why you didn't go out to your daughter's school and talk
Because
with your
Judge
teachers.
Blake told me I couldn't.
Okay, and that's in a DDPO that, according to your testimony, was thrown out but then renewed for a couple of years. Is that right?
The reason the DDPO was put into effect was based on actions that did not happen.
So,
And so after those were thrown out, the DDPO continued, even though there was no justification for it. And after the first year, when my mother died and I was back in Texas, y'all was behind my back and didn't even tell me and had a renewal for another year when I hadn't even so much as talked to anybody. There was no ground for that DDPO.
Sir, there's not been a DDPO in effect since sometime in 2004.
2 years, as I said.
Okay, so between 2004 and today, which is almost 5 years, the number of times that you've been out to see your daughter's teachers to figure out how she's doing in school is 0. Is that right?
No, like I said, once or twice in recessions, they allowed me to do so. I was following what I thought was the rules of our arrangements. And that is that I only see my daughter 3 times a week. I call an hour before, and we make arrangements in a place, and I go there. That's what I've done, exactly what I was told to do.
And in fact, during the time that you were out, quote unquote, on the street, Mr. Strickland, Sherry's father, actually brought you insulin, didn't he? Because you couldn't afford it.
When I was in the homeless shelter, he brought me insulin. I don't know if that's a great thing or a bad thing. I don't know what to say.
He brought you insulin.
I was died, yeah, that was kind of
All right.
since they put me there.
And in fact, you were allowed to come back to the home for
about 10 days prior to the DVPO hearing, isn't that correct?
Because I won in court, and I was allowed to go back in my home for 10 days before y'all put me back out again.
Mr. Getz, you're aware that, that Stephanie attends the Elm Grove Church?
Yes, sir.
Have you been there?
Yes, sir.
Okay. On what occasion did you go to Stephanie's church?
It's a public place. I've been there a number of times since I've moved here.
That's the church that the Stricklands attend, isn't that correct?
Right.
Okay. Do you have your own church that you attend?
That one primarily, I guess, and one or two others I go to sometimes.
Okay, what are the one or two others, Mr. Getz?
The one in Ayden, Anointing One's Ministry, in Farmville, two places that
Okay, tell me the names.
Methodist Church.
What's the name?
Farmville United Methodist Church.
Okay.
And the other one is just an odd name. I can't remember. I was trying to remember that day. It's downtown Farmville. They got a youth group. I work with them sometimes and the kids. I'm a substitute school teacher.
Okay. And, Mr. Strickland, you have no family other than Stephanie here in Pitt County, isn't that correct?
Right.
Okay, and Sherry has a pretty large extended family here, doesn't she?
Which is why I brought my daughter here. So
Okay.
she would have family.
Okay. And in fact, you're aware that Stephanie spends a lot of time with her extended family. Isn't that correct?
Absolutely.
Okay. She seems to enjoy it, doesn't she?
Yes. Which I don't want to change.
And you testified about an alleged assault between yourself and Mr. Strickland. That's Mr. Strickland sitting back there, isn't it?
Yes, sir.
That's when you came to his house with the video camera and demanded to know where your daughter was. Isn't that right?
I asked for my daughter was
You
there.
demanded to know. Mr. Strickland asked you to stop filming them, didn't
He jumped me before he said
he?
anything.
He asked you to stop filming them, didn't he?
No.
Mr. Strickland, yes, you make a habit of taking video cameras to places and sticking cameras in people's faces and antagonizing them. Is that what you do?
When I feel like they're lying to me and I need to document the truth and protect my daughter, yes.
Okay. And you're trying to protect your daughter on that day because she wasn't where you thought she was. Is that right?
No. Because her mother had just come home and told me she didn't love me, she was taking the child and was going to kick me down the street. I told her, please go get your Stephanie, because Stephanie wasn't there, and Mr. Strickland, and we would all sit down and talk about what's best for my daughter. Obviously, Ms. Strickland and I, Sherry Strickland and I were not going to be together. We had to make some arrangements that were good for my daughter. She left and never came back. I waited for like an hour. I didn't know what was going on. Then I realized these people are not being straight with me. They're setting me up. And I started recording the camera, and I documented it.
Mr. Getz, you got a bedroom for Stephanie in your home?
Yes.
Is there a bed in it?
Yes.
You sure about that?
Don't lie.
How long has there been a bed in her room?
I set that room up 5.5 years ago when I went there.
Okay. And in addition to not filing a contempt motion in the last 5 or 6 years that you've had a stable residence, you've also not petitioned the court to modify the order, have you?
Because I knew that by myself I could not take care of her. And I had to be able to be on my feet with a decent business, with a good income, and knowing that I didn't believe their support if I had my daughter. I had to wait. I couldn't just jump in the fight and try to fight for my daughter. I had to make sure I could take care of her.
Okay, so it's your testimony then, the very instant when you realized you had the ability financially and otherwise to take care of your daughter, that's when you filed a motion to modify the order. Is that right?
It's not a moment's decision, but over like a month or 2 or 3 when I started gathering my own attorney and trying to get this together, yeah.
Okay, so then by your own testimony until the date of the filing of the motion to modify the custody order, you yourself didn't believe that you had the ability to be the primary caregiver for your daughter and to have her in your home. Isn't that correct?
No.
Well, tell me where I'm wrong about that,
I
Mr.
believe
Gates.
that I could, but it's not in her best interest not to have family. So I wasn't going to rip my daughter away from them and keep her to myself. That wasn't good policy.
Well, tell this court when you believe that you had the ability and the financial capability and otherwise to be the primary caregiver for your daughter and to have her live with you in your home. Tell me when that was.
It has not happened. I do not believe that I can take good care of her without a family. And that is what I've been trying my best to do. And so the only reason this all started is because she sued me for child support. And so I had to defend myself, and I said to him, no, I'm not a deadbeat dad, I'm trying to take care of my daughter.
So did you just say the reason you filed a motion to modify this custody was because Ms. Strickland sued you for child support? Did I hear that
The
right?
child support court hearings is what I guess initiated most of this, that I was able then, at that point, realize that they are not going to be family for me and my daughter, and that I have to step forward and make some decisions, and I did so.
So because Ms. Strickland sought from Stephanie's father financial support, you believe that Ms. Strickland...
No. That it is clear at that point that she was never going to reconcile and be a family. That she expected to be paid for destroying her family.
Okay, so you're saying that it took Ms. Strickland filing a child support complaint to make you realize she wasn't going to reconcile with you? Is that what
I was
you're saying?
trying with all effort to try to resolve this without going to court like we are now. And at that point is when I decided this ain't never going to change. I have to do this. And I was able, and I did so.
Okay. So you're saying that sitting here today that you were capable, financially and otherwise, to be Stephanie's primary caregiver. Is that your testimony?
Well, except for the bad economy, yeah. But
No. Is that your testimony?
I am concerned about being able to take care of my daughter, like any good father would be in a bad economy with no other family to help them. But yes, I can. I will.
You can and you will.
Yes.
All right.